May be seated. Ladies and gentlemen of the jury, I understand that you have a verdict this time. Is that correct? I understand that, Mr. Reed, you're the foreperson. Is that correct? No. Who's the foreperson? Who are you? Ross. I was close. I apologize. Without telling me the verdict in this case, have you reached a verdict as a jury as a whole? Yeah. Okay. Can you go ahead and hand the verdict forms to Jane? Jane, may you approach? Mr. Buen, I would ask you to rise and come to the podium. The verdict reads as follows. We, the jury, find the defendant, Andrew Buen, guilty of criminally negligent homicide. To the jury, is this and was this your verdict? So say you all. Okay. Was your verdict unanimous? Okay. Counsel, would you like me to poll the jury?
No, Your Honor. Thank you.
Okay. Then you may be seated at this time. Ladies and gentlemen of the jury, you have now completed your duties as jurors in this case and are discharged with the thanks of the court. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons. For your guidance, you are instructed that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not. If you talk to them, you may tell them as much or as little as you like about your deliberations or the facts that influenced your decision. But if any person persists in speaking to you over your objection or becomes critical of your service either before or after this case or before any discussion has begun, please report it to me. At this time, you're discharged. You're not entirely excused because I'm going to come back and talk to you for just a moment. I have a few short things that I need to take care of here in the courtroom. So at this time, you are excused back into the jury room. You may be seated. At this time, are there any additional motions?
Your Honor, the people are asking for remand 16-4-201.5, right to bail after conviction. The court may grant bail after a person is convicted pending sentencing or appeal only as provided by this Part 2, except that no bail is allowed for persons convicted of subsection 1E, any felony during the commission of which the person used a firearm.
I also believe that statute does require immediate remand if there's any conviction for a charge of murder.
Correct.
So
Your Honor, can we have just a moment? That's not my understanding of a crim neg conviction. The charge itself is probation eligible, so I don't know that it would require mandatory remand pending sentencing. Obviously, it would be our request that he be allowed to not be in custody pending sentencing. Certainly, he's entitled to a PSI, and having him out would assist us greatly in preparing sentencing mitigation paperwork. Crim neg's not a crime of violence, Your Honor, so I don't know that remand is required.
16-4-2015, section E.
16, 4, 201.5.
But I just looked at it this morning. To what, 16 point
One
what?
E says any
No,
felony.
no, what?
16.4.201.5.
Thank you.
201.5.
Your Honor, can we have a recess for like 30 minutes so we can do our research?
We will take a recess for 30 minutes.